Thank you, Mr. Chairman, and I'd like to start with Ms. Link and Mr. Parker. And what was the stated reason given by the Forest Service to justify taking water rights from ski areas and ranchers?
Thank you, Congressman Tipton. And I also want to thank you on behalf of the ski industry for your focus and support on this important issue for ski areas. We appreciate it very much. So the stated reason by the Forest Service for this policy, and again I emphasize the stated reason because it might not be the real reason, is to sustain ski areas and ski communities in the long term by tying water to the land to stop ski areas from selling off water rights.
Mr. Parker?
Very similar. They want to control the water so that they can then manage the land for the livestock that is associated with their charge of multiple use. The interesting thing is, and I appreciate this question, Congressman, Utah already passed in state statute that the livestock water right, those that are occurring out on federal grazing allotments are pertinent to the allotment and belong to the grazing permittee. So we've already dealt with it. This is overkill.
So the federal government is effectively saying we want to make sure you're using that water for grazing. We want to make sure you're using that water for snowmaking. So I want to ask this question, Ms. Link. Have ski area operators been selling water downstream for more profitable uses?
No, that has never happened.
Never happened. So it's not a problem. They're trying to correct something that doesn't exist.
That's correct. It's a made-up problem.
Great. You know, you've mentioned you've tried to negotiate with the Forest Service to sustain ski areas for future generations without relinquishing your water rights. In the past, what's been the response from the Forest Service?
The Forest Service has not been open to a ski area water rights clause that falls short of giving the U.S. government ownership of our water rights. So
it's their way or the highway, or I guess now we have to call it the blue way?
That's correct.
Okay, great. In your opinion, what do you suspect they have asked? Why have they asked for nothing short of just literally full title to those water rights?
We believe that the Forest Service is really trying to get what we call water for the woods. And what I mean by that is protection for aquatic species and aquatic habitat. This position was actually articulated in a law review article in 2001 by the Forest Service's lead water counsel, Lois Whitty. In that article, which is called Still No Water for the Woods, she criticizes Supreme Court precedent that requires the Forest Service to obtain water rights under state law, and she argues that the Forest Service should reject state law mechanisms and use its authority to condition permits for occupancy of Forest Service lands to seize water rights from private permit holders. The agency's most recent explanation for its water policy, which is saving the ski areas and the ski communities, is really just a cover for this long-standing objective of getting more water for the woods for these other purposes. If the agency were truly aiming to keep the water with the ski areas, why, under its 2012 policy, for example, which was struck down in federal court, was the Forest Service not willing to guarantee that the water would actually stay with the ski area? That is a big question for us.
So under the guise of keeping the water for your purposes, Mr. Parker, in terms of the grazing end of it, there's actually a little nefarious idea in terms of they want to be able to direct that water for what they perceive is the best beneficial use.
Yes, and if I might add, in the case of the state's water that's on the federal lands, those permittees are required to turn over a portion of their water right or risk not being able to develop it, to maintain it, or use it. They literally will not give a permit onto the land to do those things that put their water to beneficial use. It's frustrating because we have a 7-year forfeiture law in Utah, and once it's not used for 7 years, it's forfeited back to the state of Utah. And at that point, who stands in line to benefit from that forfeiture?
Right. Well, Mr. Parker, Ms. Link, given the far-reaching implications of the federal water grabs on public lands, what action would you like to see in order to stop these harmful efforts and to be able to protect our water rights for Western economies?
We would welcome legislation that prohibits federal agencies from using permit conditions that require transfer of privately owned water rights without compensation.
And we'd like to see the federal government not able to hold water rights, but work with the states to meet the objective. Work collaboratively instead of the way it's happening today.
All right, thank you. Mr. Lamont.